Room.
We are live.
Thank you. Good morning. I'm Senate President Pro Tem Becca Ballant, and today the Senate Committees on Education, Health and Welfare, and Judiciary are meeting to take testimony on allegations of abuse at Kern-Hatton Homes for Children and on related investigations by the state of Vermont. I'm here this morning to speak briefly to the Senate's role and our goals in this effort. Our main goal is to shine a light on an extremely difficult and troubling issue and help ensure that bureaucracy, overlapping jurisdiction, and conflicts of interest aren't jeopardizing the safety of children. We also hope to ascertain whether there are any statutory changes that will allow us to better address this issue and others like it. For many of us in the Senate, this issue was first brought to our attention through public reporting in September of last year. We learned that the Department of Children and Families had recently completed an investigation and report related to alleged sexual abuse and misconduct at the school, and that Kern-Hatton had relinquished its license to operate as a residential treatment program. I want to note that there is, among the parties, disagreement over whether the school voluntarily decided to give up its license or if it was pressured to do so. Subsequently, the Agency of Education asked the State Board of Education to review the board's status as an approved independent school. The board concluded it could only do so after an investigation conducted by the agency. Our understanding is that this investigation by AOE is ongoing, though nearing completion. In addition to these investigations into recent complaints at the school, VT Digger reported on allegations of abuse that may span decades. Again, for most senators, because of the emergency of the pandemic, this issue fell off our radar until last month when we began to hear from parties who felt strongly that this important issue was perhaps being overlooked and that we as legislators were not doing enough oversight. In the lead up to this hearing, we've heard from multiple interested parties, all concerned that in addressing this issue, the Senate may miss critical perspectives or points of view. These concerns are understandable as this is a very troubling issue. Every senator at this hearing understands the gravity of the topic. We want to emphasize that we are not a court of law. As a citizen legislature, we are trying to get at what we need to do in our important role to promote safety and accountability. We do not sit here as prosecutors nor as a jury. We represent Vermonters from across this state who all want to be sure that children being educated in Vermont are safe and secure while they're attending school. Before we begin, I want to reiterate that we know that these topics are incredibly difficult. We don't know what history and personal experience those attending the hearing have had when it comes to abuse. I encourage all of you to do what you need to do to take care of yourselves throughout this meeting, including turning off your video or stepping away for a few minutes. With that, I will turn the hearing over to the Chair of Health and Welfare, Senator Ginny Lyons, who will introduce our first witness.
Thank you, Senator Ballant. Your leadership in this has been extremely helpful and outstanding. And we appreciate your comments. We as senators understand that there's nothing more important than providing a positive culture for our children. And we each have heard disturbing information that's happened to children at the Kern-Hatton School over the past decades. So today's our opportunity to begin oversight. Each of our committees will most likely continue to understand how we can make improvements going forward. So with that, I'd like to have Senator Sears and Senator Campion introduce themselves as chairs of Judiciary and Education, and then I'll introduce our first witness. Senator Campion.
Sure. Thank you, Senator Lyons and Senator Ballant. I'm Brian Campion, State Senator representing Bennington County and Wilmington. I serve as the Chair of Senate Education. We did start having a conversation last week in Senate Education with the Agency of Education, Ms. Emily Simmons, who will also be joining us here today, where we started from our purview to look into the issues where the Agency of Education has had oversight. And that will be what we will continue to look at today. I want to let those who are here and watching know that we are an afternoon committee. And so there are senators who are in their morning committees, but we also have some overlap with Health and Welfare Committee. And we have 3 members from that committee on education who are with us this morning. So with that, I'll turn it over to Senator Sears.
Thank you, Brian. I'm Dick Sears from Bennington County. I'm here to basically listen and to learn more. We have in our Senate Judiciary Committee S99, which would change the statute of limitation for child physical abuse. A few years ago, we took the serious step in one of the few states in the nation that has eliminated the statute of limitations for child sexual abuse. And I believe some of the suits are based upon that law that was changed. So Judiciary will be looking at S99, may call some of you in as witnesses. I also must mention that part of the motivation for S99 was the cases at St. Joseph's Orphanage in Burlington. So it's more than just this. And I think I'm hopefully listening and will be listening and trying to understand, but I'm deeply concerned about about the past and the documents we've seen that indicate this abuse has been going on for at least 50 years at Kern. And so while Commissioner Brown is relatively new to DCF, prior to that, there was SRS. Prior to that, there was social welfare that had the responsibility for kids. So I'll be particularly looking at some of the history and some of the information that we have in the past of why this wasn't brought out sooner, or what was done and what wasn't done. So thank you very much.
All right, thank you, Senator Sears and Senator Campion. And I am Senator Jenny Lyons. I do chair the Health and Welfare Committee, and our concern relates directly to the report that was completed by DCF that delicensed Kern-Hatton for oversight of children as who are in state custody or guardianship. We will continue our discussion on this after this meeting. There's no question about that. We really need to understand all of the issues that relate to us in our role of oversight. I don't want to talk further today, but I will say as ground rules, if you are not speaking, please mute yourself. And for those of us who are in the Senate, one of the frustrating things about today is going to be the inability for us to carry on a long dialogue, but we'll try to have that happen in our individual committees as we go forward. So I'm going to ask Sean Brown, who is here. Welcome, Commissioner Brown, Commissioner for the Department of Children and Families. And as Senator Sears has suggested, you are relatively new to your position, and so new to the investigation and the information related to Kern-Hatton. So we'll listen to your testimony and appreciate the time that you're giving us.
Thank you, Senator Lyons, and good morning to all members of all 3 committees who are here this morning. This is a incredibly difficult topic and conversation, and we recognize that, and we share the concerns of the committees, regarding others who may be participating and whose trauma histories could be triggered by conversations today. And we too do encourage anyone who's watching to practice self-care. And also we recognize that there will not always be agreement between different players involved in this conversation today in terms of what may have or may not have happened. And we're happy to provide as much information to the committee as we can regarding these matters. There's some things that we're able to talk more freely about, and others we're not, just given the sensitivity of certain types of abuse investigations that may or may not have occurred related to Kern Hatton. With me today, I have two fellow DCF employees. We have Jennifer Micah, who is our general counsel. And then also we have Jennifer Benedict, who is the director of our residential licensing and investigations unit. And I thought it would be helpful to provide some general information to the committee regarding Jennifer Benedict's unit and their role in licensing and overseeing residential licensing programs, but also their role in when there are specific allegations of abuse in residential treatment programs that we oversee, what their role is in investigating those as well. And then we can then move on into more specifics regarding Kern Hatton, but I thought it would be important for the committees to understand our role in general with residential licensing programs and investigations of abuse that may have that we receive from children in those programs. So Jennifer, if you be willing to provide an overview for the committee. Thank you.
Certainly. Thank you, Sean. And good morning, everyone. Can everyone hear me okay? Excellent. Audio can sometimes be challenging with my computer. So as Sean introduced me, my name is Jennifer Benedict. I am the Director of Residential Licensing Special Investigations Unit, and we are seated within the Department for Children and Families in the Family Services Division. We are a unit of approximately 12 family services workers who are dispersed statewide in home-based offices in order to fulfill our unique function, which I'll explain further. So our unit within Family Services Division is responsible for two unique functions. One being the special investigations function, and the other is the regulatory function, which I'll explain in more detail in a moment. The special investigations role is unique to the division in that we conduct child safety interventions, some know as Chapter 49 investigations, which is reference to the statute, which I'll talk about again in a few moments. We conduct child safety interventions in various settings where children are, state-regulated settings, such as foster homes, child cares, Agency of Education approved public and private settings, as well as residential treatment programs, which is what's relevant to today's topic. We also conduct child safety interventions when there are allegations against others who meet the statutory definition of person responsible for a child, which is again in the statute. And let's see, examples of those types of cases would include residential camp counselors, members of the clergy, various other professionals who are in a professional caretaking role of children. And they run the gamut each year. The third category of child safety interventions we are responsible for are conflict investigations within the department when allegations of child abuse and neglect are made against either department employees, excluding Family Services Division employees, or we have caretakers who are department employees. Sometimes we have co-located providers that work very closely with our district offices, and our unit conducts those investigations as well. All investigations related to law enforcement also come to our unit. They are considered a conflict of interest case for most district offices. My unit, because of its long title, is commonly referred to as RLSI. It doesn't roll off the tongue, but with some practice, it does come out a little quicker. RLSI is responsible for following the same statutory and policy requirements as those conducting interventions in our 12 district offices. Those include various timeframes and notifications of parties, as well as, interviews of specific parties in investigations, and certainly closure requirements, among many others. Child safety interventions have very specific and stringent confidentiality provisions, which are referenced in statute. And the specific citation is Title 33, Chapter 49, subsection 4921. This section outlines the specific scenarios that we can disclose records, and it's fairly limited in contrast to our second function, which is the regulatory role. That's a brief overview of child safety interventions, and I will also explain our second role, and I'm open, of course, to any questions to clarify process and procedure along the way. Our second function.
I actually have a question.
Yes.
Could you be more specific about limited disclosure of investigations? So if we wanted to know there was an investigation at Kern Hatton home in 1982, would we be able to find that information? Or is that not able to be disclosed?
Well, Senator Sears, that's an interesting question, because that time frame predates most of our record keeping, either in paper file or in our database, our existing database. So that would present one potential barrier. It is possible such files exist. However, it's my understanding that unless that would fall within a state entity conducting a related inquiry, such as the Agency of Education conducting a related inquiry through our existing memorandum of understanding, we would be unable to disclose that information.
So a legislative committee would need to get special authority to get information.
That is my understanding, yes.
Okay.
Let me add a question to that. Given that some of the records are before the time that you were actually keeping records, what about the records as a result of Irene? How far back do the records go?
It's a good question, and I'll be as precise as I can in a response. So our record keeping throughout the division varies. Let's see. Our current electronic database is called FSDNet. That is what we use today, and it manages both ongoing caseload tasks as well as front-end child safety interventions. That came into existence in 2004, I believe. Prior to that, each district office maintained its own paper file for both ongoing cases, custody cases, and front-end child safety intervention cases. When we have requested old files, as we do regularly when we discover there's history or alleged history in one of our cases, we rarely receive records that date back into the 1980s. The late 80s sometimes produce investigation files that are substantive. This is anecdotal, but prior to 1985, they're virtually non-existent. They exist in public records in archive and must be requested by using certain information specific to the case. The other database that holds the bulk of our information, which is what our child protection registry is based on, that dates back into, I believe, 1986. Please don't quote me on that, the mid-1980s. So there may be indication that there was an investigation or some sort of intervention or ongoing case in that time frame, but the corresponding file may or may not exist. Does that answer your question?
And if I could jump in here too as well, senators, in response to your question, as Senate Pro Tem indicated, this issue was in the news last fall As a result of some of that reporting, we have had additional public records requests, and some of them ask for records that go back in time, a significant period of time. And our public records officer is working to identify, the records we have, particularly the older records, and then what is available to be disclosed publicly as a public record or not. And we're certainly happy to share our findings once that work is complete with your committees.
Okay, thank you. And one last question in this direction, and that is, how far back do the records go that you used in your investigation for the licensure investigation that you completed last fall?
Well, let's see. That's a tricky question to answer, and I think it will become clearer as I explain the application of the regulatory role, because each program is licensed for a term of licensure, and then at the point of relicensure, we assess 2 years prior throughout that term. Does that make sense?
Thank
for
you.
now? Yes. Okay, so the special investigations function is one. The second function of our unit is the regulatory role. We are responsible for licensing and regulatory oversight of state-regulated settings for children as well, such as foster homes, licensed child placing agencies, both the foster care aspect of those agencies and the adoption agencies fall within CPAs, the commissioner designated shelters, and the residential treatment programs throughout the state. Our regulatory role includes sort of start to finish oversight, which is part of, part of the magnitude of this part of our function. It includes an assessment and evaluation of suitability as to whether or not each of these entities meets compliance for the respective set of the regulations. And it includes ongoing oversight as well as renewal at the appropriate interval of time. Each of these entities, foster homes, child placing agencies, commissioner designated shelters, and residential treatment programs, have different license terms, and some of which is governed by rule, but our unit has great discretion in terms of how we apply the terms of licensure, depending on the status of the license. As part of the regulatory role, we also perform and conduct regulatory interventions when there are allegations of violations of regulation. The purpose of these regulatory interventions is certainly to determine compliance with regulation, but most importantly is to educate the regulated entity and to enhance the quality of care in each of these settings for children. Part of the difference in the two interventions that we have is that they have different outcomes. Regulatory interventions have a range of potential outcomes, which could include no action whatsoever because we determine there's no merit to the regulatory allegations. It could include citation of violations and no further licensing action. It could include citation of violations and a restriction on the license. And in far fewer circumstances, it could include a license revocation. It's common for both the regulatory intervention and the child safety interventions that we do in our unit to occur simultaneously, because most complaints that we receive regarding regulated entities come through the child protection hotline. Most people call it the 800 number or the centralized child abuse hotline. When those calls are received, they are screened by the centralized intake screening unit that receives all calls and complaints throughout the state. And there is an initial decision as to whether or not the information provided meets criteria for a child safety intervention, a child abuse and neglect investigation, in other words, or if it's not accepted, it will be sent to the respective district, in my case, to our unit, to RLSI, for consideration as to whether or not it meets criteria for a regulatory intervention. Oftentimes, as I mentioned, the two are occurring in tandem, and we wear two hats when we are investigating both child safety interventions and regulatory interventions. It provides a continuum of assessment in sort of each of these environments. So,
Jennifer, I'd like to ask you a question as we're going along, and you'll
yes.
have to excuse the noise you hear. It's jets going over. Sorry, everyone. As you're going through the conditions that you're talking about for regulatory intervention, might you indicate to us where your investigation began? So under what conditions were there complaints made, and how many complaints made over the hotline, if that was the instigation for your investigation? So just to give us an indication of how this played out with the Kern-Hatton delicensure revocation, which you have indicated is quite rare.
It's true, Senator Lyons. I appreciate that. The way we had planned to provide information to this joint committee in this hearing was to give background information and then to get more specific as it related to Kern-Hatton. I can say, to answer your question and to be clear, we did not revoke the license of Kern-Hatton, their residential treatment license. It was closed in September of 2020. And there is a distinct difference there in that when there is a closure, there is some level of agreement at the point prior to and at the point the closure occurs. A revocation is when there is so much. A revocation occurs when an existing facility needs to be regulated, meets the requirements to be regulated as a foster home or residential treatment provider, and there is disagreement around compliance, and our unit feels as though the licensed entity can no longer meet the requirements and should no longer serve children.
Okay, thank you. Unless you're, if you're going to get to to answer this question, that would be helpful. But the question was, when did your investigation begin? Under what conditions? What promulgated or precipitated the investigation?
Sure. So I'm just about to that point, actually, in giving a
Good.
general
Okay,
sense of
thank
what
you.
we're doing. I appreciate your patience. In addition to the discrete interventions that we do in all of these facilities, we also have routine licensing tasks, which means we constantly are assessing and in contact with our residential treatment providers, as well as other regulated entities. We schedule renewal visits. In this case, for residential treatment programs, that is every 2 years. That's a standard term of licensure for an RTP, which is a residential treatment program. So how we entered the Kern-Hatton situation in the most recent licensing report, and I want to be clear, the document that we created and that we drafted that was then released, and that I believe everyone has seen and is referencing, that is what we call a licensing report. And those occur at every initial application as a full assessment as to whether or not people are in compliance, and then again at each licensing interval at what we call the renewal. So for most residential treatment programs, we conduct a renewal, which is a full program evaluation every 2 years. So in 2017, we were conducting a routine licensing visit of Kern-Hatton and a routine licensing assessment upon renewal. It expired in 2017. And we started having very clear discussions with Kern-Hatton because it became increasingly apparent that Kern-Hatton was not functioning as a residential treatment program. Kern-Hatton leadership agreed and mentioned that they had every intention to to seek out accreditation from another body, which is referred to as NEASC, New England Association of Schools and Colleges. And they were hopeful that that process would be complete in early 2019. As a result of things that were identified in the routine licensing visit in 2017, as well as the program's desire to explore closing their residential treatment program license, my unit agreed to extend their license and renew it for 1 year rather than 2 years to allow further time for my unit to assess their compliance, as well as Kern-Hatton to officially engage in the NEASC accreditation process. In 2018, we realized the NEASC process was taking much longer than anticipated, not to any fault of the program. They initiated as they stated they would, and we renewed their license. We allowed for their license to continue in good standing as we continued to have regulatory oversight and until there was more clarity about the timeline for the NEASC accreditation. In mid-2019, the NEASC process was still underway, and there were significant delays. And so we were approaching the end of the 2-year cycle. Remember, in 2017, we were renewing. We issued a 1-year license, and then in 2019, it became apparent that it would not be complete by the time the 2-year interval would be expiring. So we scheduled a follow-up renewal licensing visit in the fall of 2019. And that is when we conducted another thorough review of Kern-Hatton records, regulatory complaints, staff interviews, etc. A full and routine licensing visit. That is when we identified the numerous non-compliances as cited in the report that you reference.
So the time frame that you included in that report, and by the way, that report is not yet on our webpage. It would be helpful for us to have that. So the time frame that you used to determine compliance or non-compliance for that renewal, how far back did you go?
I'm not understanding your question. I'm sorry.
How much information did you use? Is it when you do this renewal process, it's a 2-year renewable process? Do you look only at the 2 years of operation under the existing license?
Generally, yes, because at each renewal, there would be an expectation that you're following up on any complaints, themes, program changes that occurred within that 2-year interval. So yes.
Okay. All right. And so were there complaints that drove your reconsideration of the license? Whether it was agreed upon a closure or whether it was regulatory delicensing, did you what information did you use?
Yes, there were complaints received throughout the period of 2017 to 2019, which would have been a 2-year look back, if you will. There were numerous complaints received throughout this time, and those were used as part of the assessment and ultimately the report that was written that hopefully you will receive soon.
All right, thank you. Okay, Senator Sears has a question.
Thank you. What is the nature of those complaints? If you might be able to let us know, were they from individuals? Were they from social workers? Were they from, and what were the nature? What were they? What were those complaints?
Sure. So I can provide you what I am able to do within the limits of confidentiality, keeping in mind that most complaints that we receive are received through the Child Protection Hotline, which comes with some protections in terms of anonymity of reporter source.
Understood.
Okay, so I will say that we receive complaints from a variety of sources, ranging from all the parties that you just mentioned. Without having each in front of me, however, having supervised many of them, I can say with certainty that it was not one particular source, but we received from a number of parties.
Again, and maybe you don't have that information in front of you. If it's confidential, I'd like it available to this joint committee. The nature of those complaints, and I've seen complaints before. I ran a residential program, so I've had complaints. I understand that they come, they need to be investigated, and sometimes they're found unfounded. Sometimes they're, but there is a thorough investigation. My experience tells me that. DCF, at least DCF now, back in the day, SRS did thorough examinations. I'd like to have that information, but it's confidential. It can go through our lawyers, but I'm requesting that. So we have a sense of, from 2017 to 2019, what was the nature of the complaints against Kern Haddon School?
So thematically, I would be happy to provide that. And to be fair, majority of this information is found in the regulatory report, which is a very different, there's a different ability to share that information than there is to those circumstances tied specifically to a child safety intervention. So I really hope that all three committee members, I'm sorry?
I personally understand that. We have had, I completely understand that. I'm just trying to determine the nature of the complaints that led you and Kern Haddon to, and I still don't know exactly what happened here, but there was a decision made to no longer be a residential treatment program. Something happened. There was that decision made. I think it's important for this committee to understand that despite the past allegations, despite the information that may be lacking because of the age of the complaints, we still were in 2017 having complaints made, and were they substantiated? That's what I really want to know. Were they substantiated by the Department of Children and Families, or were they not substantiated, and what was the nature of those complaints? I'm not asking for the specific individuals, but rather the nature of the complaints and whether or not they were substantiated.
Senator, if I could jump in here, I think we'll be able to provide you a summary of what you're looking for each incident where we received a complaint or allegation involving Kern Haddon for a child safety intervention. Not the regulatory, but I think you're asking for the nature of what we might have received for information through the hotline and kind of what happened with
or
that.
from individual children who might have made a complaint that they were abused at the home, or some other, that they weren't provided proper food or whatever. So it's important for us to understand the nature.
Sure.
Senator, you've identified something that's absolutely critical and important to us, particularly in health and welfare, and I know also for your committee and for education. Having the information about what complaints actually were related to the 2017-2019 timeframe. But beyond that, I think it's important for us to understand what complaints were made prior to that time. And so, because I think that is what has driven so much of the concern publicly, as well as here in the Senate. So the information that you have, whether it can be aggregated so that it is confidential, I think is critical for us to understand the entire issue.
Well, I want to clarify, I totally agree with you, Senator Lyons, but I I was particularly referring to the statement that in 2017, routine licensing visit with Kernhatten it became clear that they were not functioning as a residential treatment program. They extended the license for 1 year rather than 2, trying to determine what was going on in 20. Specifically, that's, we talked about the prior records in the 80s. I'd like to see every record they have of investigations and whether or not they were substantiated. That's the key term, I believe. Is there a middle ground of not substantiated, or is it?
Well,
I'm trying to refresh my memory.
Sure. You have the correct term for child safety interventions. You're correct, Senator Sears. It's either substantiated or unsubstantiated. There are regulatory interventions, however, that result in violations or not violations. And so I want to be very clear. Oh, sorry.
Sometimes there's exit signs. Yeah. Sometimes there's exit signs that are not properly placed or not even in the building. And that would be a violation of the regulations.
That ranging all the way up to more serious violations of lack of supervision, admitting students that did not fit the services the program was designed to provide. And so while they are distinct processes, they are both looking at the same information, and they're both intertwined in terms of how we assessed Kernhatten at each interval. So it sounds like you would like to know thematically, which I would like to provide you, because that is subject to discussion, and that was mentioned in the regulatory report. The nature of the complaints ranged from lack of supervision, both in the the broader program and in the cottages themselves. Within Kernhatten, many of our complaints allege child-to-child sexual contact. And whether or not they were accepted as a child safety intervention is irrelevant, because we look at themes over time and what emerged. Lack of supervision, admitting children, staff training at times appeared to be inefficient, and not reporting suspected incidences of child abuse and neglect.
So that would be the failure to report. They're mandatory reporters, and they fail to report. Okay. Thank you.
So yes, this is an area that we're going to absolutely need to continue with the discussion. Unfortunately, we're going to have to. I'm sorry to say, we're going to have to move away from DCF for the time being. Ask you to please stay around because we would like to get back to you, but the Agency of Education is on a very narrow time frame, So we're going to ask Jennifer for last comments at this time, and then we'll move to the Agency of Education. And one other comment, and that is, we understood we were going to have the report on our webpage, but we haven't not yet received it. So I'm reaching out to DCF to ask to get that to Nellie Marvel, please. So Jennifer, last wrapping up comment, please.
Yes, definitely. After the 2019 licensing review determination of various areas out of compliance, my unit sought frequent consultation from our department legal counsel, and it was determined that the best course of action would be to reach an agreement with the program, because they were not in form and function operating as a residential treatment program, to agree upon residential treatment program license closure. That did not mean the rest of the program would cease to operate. That meant that the program could no longer advertise as a residential treatment program, and needed to be clear about that with other sending states within Vermont, and to be in abidance with the stipulated agreement that was outlined in the closure letter in September 2000, initial letter, summer of 2020 in June, which I believe you will also receive a copy of. and the final closure letter in September 2020. Since September 2020, we have no regulatory oversight, but my unit is still responsible for responding to incidences of child abuse and neglect that occur within the facility. However, as we've talked about repeatedly, we would be unable to discuss such matters at this time.
All right, thank you. We have a clearer picture of what has happened and what you can and cannot do. So our committee at least is going to follow up on this. Some of the issues you've raised are concerning to us, not just from the child treatment perspective, but the whole regulatory process. I won't say any more at this point, but because we do need to move on. But thank you all for providing us with some testimony. And please, if it hasn't already been sent to our committee assistant, please do send that. Commissioner, I'm hoping you'll be able to do that for us.
I believe they've just been sent, so they should be, Nellie should have those documents.
Terrific, thank you. That's great. All right, so we're going to transition to the Agency of Education, and then we may have some time to come back to DCF. And we'll keep you here. Thank you. All right, Secretary French and Emily Simmons are here. Why don't you introduce yourselves for the record? And perhaps before you do that, I would turn to Senator Campion, if you'd like to say something at this point.
Thanks, Senator Lyons. The only thing I want to reiterate is that we did hear from Ms. Simmons last week, who provided testimony. That testimony was, of course, recorded, and I would encourage senators and others to review that testimony for additional background information. I do suspect that and hope most of that will be repeated today. We, as you know, the Agency of Education is currently has an ongoing investigation, which has been going on for 2 months. And I think a good way to frame this is for an update on that investigation, what prompted that investigation, as well as the period of time between when the Agency of Education learned about the DCF report and when the investigation actually began. So with that, I'll turn it over to Secretary French and Ms. Simmons.
Well, good morning. Thank you for the opportunity to testify. Dan French, Secretary of Education. Emily, if you want to introduce yourself.
Emily Simmons, General Counsel, Agency of Education.
And again, thank you for the opportunity to testify. As Senator Campion indicated, Emily has provided testimony on behalf of the agency previously in the Senate Education Committee. I'm happy to review that today with you. By way of introduction, I would just say that to Senator Campion's point, we are in the process of reviewing the Current Hatton school and compliance with our regulatory oversight. I would just point out the Agency of Education does not investigate child abuse or criminal activity, but we do have some regulatory oversight in this area. And Emily, perhaps you'd like to just sort of review that a bit with the committees.
Thank you, Secretary French. Yes, in the way of table setting or giving context to the Agency of Education's interaction with schools like Current Hatton, I would like to tell you about Current Hatton's status as an approved independent school. If you're not familiar with that term of art within the education field, that means that Current Hatton, as an approved independent school, is eligible to receive public tuition dollars from Vermont school districts that pay tuition rather than operating a school for one or more grades. An approved independent school is one category. The other is a recognized independent school. The category of recognition is a lower standard of agency oversight and intervention. The two together mean that if you attend a recognized independent school or an approved independent school, the student's attendance meets the mandatory attendance in public school requirements, the compulsory attendance requirements in law. Other than that, there are places that students go to school, but they also have to be enrolled in a home study program in order to meet those compulsory attendance requirements. So Kern-Hatton, as an approved independent school, must comply with the State Board of Education's rules for approved independent schools and is periodically reviewed for renewal of approval status. The last approval of Kern-Hatton took place in May of 2017. The regular terms of that approval would normally last through June of 2022. I would like to tell you a little bit about the student body at Kern-Hatton, the enrollment information. Students from other New England states make up the majority of Kern-Hatton's student body. The school has 47 residential students and 11 day students. One of those day students is a resident of Vermont Town, and that is the only publicly funded Vermont student enrolled at Kern-Hatton this school year. So to make the connection more clear for you, approval means that students can attend the school on a publicly funded basis, and this school year, one student has been using that public benefit to attend Kern-Hatton. All students enrolled at Kern-Hatton are in the custody of their parent or their legal guardian. And that has changed over the years. In previous years, I believe you would have heard from DCF that there could have been Vermont students placed there, but that is no longer the case. So as you've heard in the fall, DCF and Kern-Hatton agreed to close the school's residential treatment license. That notice came to the Agency of Education along with the report that you've been discussing, and the contents of that report initiated concerns at AOE with several elements within the report that seem to indicate noncompliance with the state board's rules for approved independent schools and the statutes that apply to schools. So AOE began making inquiries with Kern-Hatton and working with the state board in September. That led to the ongoing AOE investigation that has been discussed, although we cannot share with you the details of that ongoing investigation at this time. I can tell you as a matter of public record that two of the requirements of the secretary to the investigation committee were to investigate the information about failure to report under the mandatory reporter statute and compliance with staff background checks that are required by 16 VSA 255. As Chair Campion said, that investigation began in January and is ongoing. We expect that the investigation is in its final or wrap-up stages, but will not share an exact date for when it will be concluded. When the investigation is concluded, the result will be a written report provided to Secretary French from the investigation committee. It will be Secretary French in his discretion who will determine whether the report justifies a state board hearing to consider revocation or suspension of the approval status. And that will be the state board sitting in a quasi-judicial role, taking evidence on that matter and issuing a decision. Finally, I would just like to say, as I said to your committee, Senator Campion, I would like to be invited back, if that's the will of the committees, when the investigation and, if applicable, the state board hearing have concluded, so that we can share with you any lessons learned coming out of this process. We expect that there will be reflections and potentially some requests for changes to statute.
Thank you, Emily. Just to, as by way of information, when we begin talking about mandatory reporting, that covers a broad spectrum of folks. So it goes, it will go to all of our committees. So it will be helpful for us, each of us here, Judiciary, Health and Welfare, and Education, to receive the results of the investigation, please. All right. Senator Campion.
Thank you. I think one outstanding question I'm wondering that if Ms. Simmons could talk a little bit about that came up when we talked about in education was the time that DCF put this report out and the time that the Agency of Education picked it up and started the investigation. And I'm wondering if you can help us to understand that time frame. We also know there was some discussion at that point, please correct me if I'm wrong, on whether it was the state board that had oversight of this or if it was the Agency of Education. If you would just say a few words about that period of time.
Sure, I can. So immediately on receiving the report, we discussed it internally in the agency, and we also shared it as a heads up to the State Board of Education, since it's their rules that seem to be implicated. So the involvement of the Agency of Education started when we did receive that report from DCF. However, as you point out, the formal investigation under the specific state board rule that calls for an investigation committee that writes a report did not begin until January. The reasons for that involve the state board requesting information from the agency so that the state board could take action on its own part, and discussing the potential state board actions at the September and October meetings of the state board, as well as later, once the Agency of Education was told by the state board that the state board would not go first, that the agency needed to go first. We then had a little bit more of a delay because of appointments to the investigation committee that is required by the state board's rule. So in way of background there, the state board rule requires the secretary to appoint an investigation committee that must be composed of at least one member of the Council of Independent Schools. It's a group that's established in statute, headmasters of independent schools who provide advice to the Secretary of Education. One member of the council was originally appointed, who then had to later recuse themselves for conflict of interest or perceived conflict of interest. And so we needed to appoint a new member to the committee before they could formally start on their work.
I'm looking to
Other
colleagues who might have
questions?
questions.
Other questions for AOE?
I'm wondering if Secretary French wants to say anything at this point.
Yeah, I would just add, so if you have an understanding of the process, this committee's work is wrapping up. They will produce a report to me. I would just observe that also it's been somewhat a little more challenging than normal to do this type of reviews with the COVID pandemic. So typically what I've observed in the past when reviews are done, it's largely on site. There's a lot of record requests, certainly interviews and so forth. And, with COVID, that's really made that impossible. So we've been doing all that work the team's been doing remotely. Which has certainly contributed to the complexity of what's being done. But it's also very important that this is done thoroughly. So I know and certainly appreciate the interest in this topic, but it is moving forward and should be drawn to a conclusion here fairly soon.
Regarding the thoroughness, if I may, Senator Lyons, would you mind saying just a few words about what the investigation looks like, whether it's an interview process, site visits, history of the institution, all those kinds of things would be helpful, I think, for us to understand.
Yeah, I can take that one,
Go ahead.
Secretary French. So we won't say much about the content of the investigation. Indeed, Secretary French and I have an arm's length from the investigation itself, since it will come to the Secretary when it is complete. We don't want to have early indications that might influence that decision before we have all the information. But as I said to your committee, Senator Campion, I do know that the investigatory tool that has been most useful is interviews, and that these interviews are being conducted over the Teams platform. We have found in other AOE investigations previously in the pandemic that is a really worthwhile tool, and that an interview can be conducted over Teams that is almost just every bit as good as one in person. So that has been fortunate. We've also requested voluminous records from the school. And as far as timing, the main focus of the investigation has been since the last approval standard, or the last approval of the school, which was May 2017. However, the committee was not going to close its eyes and ears to facts that might be pertinent before May of 2017. So we don't know yet exactly how much of the report will focus on one period of time or another, but the most clear authority that the state board has is obviously since the school was last reviewed and granted a new approval.
I think a final question that I want to ask that I asked in committee when you were in it, and that is, do you believe, are you confident that the children that are in school there now are safe?
That is what we're finding out big picture. And as I told your committee, we have confidence in our DCF partners and in law enforcement to also do their job. So AOE is doing our job to ensure compliance. We're fine where there's non-compliance with the laws that apply to independent schools. However, as the secretary said earlier, if you're concerned about, or there are questions of violation of the child protection laws or the criminal laws, that's not AOE's authority. However, if we find anything that's not known already by our other partners, we will be forwarding that information to them. And we're not waiting until the end of the investigation to forward any of that information. That's happening immediately.
And then finally, another final question. Are there, and this might also have to be answered by DCF, but are there eyes on the ground? Are there people from DCF or the agency or others that are monitoring the situation given the graveness of the accusations, just to confirm that students are safe at this point?
So as Secretary French said, there are no Agency of Education staff physically visiting Kern-Hatton. However, I would classify the investigation as a type of monitoring that's ongoing at this time.
Okay, thank you. Senator Lyons, I pass it back to you.
Yeah, so thank you. I guess you have raised an important question. So DCF, and I look to Commissioner Brown and to Jennifer Benedict to confirm, has indicated that DCF no longer has responsibilities associated with Kern-Hatton. Is that accurate? So do you have any investigation going on, or as you receive any complaints, as you might receive complaints of abuse, do you then have DCF folks engaging with the school?
Thank you for your question, Senator. And I would defer first to Jennifer Micah in terms of any regulatory role we may have, and then would defer to Jennifer Benedict on any current investigations that may or may not be Chapter 49 investigations that may be occurring. Jennifer Micah?
Yes, this is Jennifer Micah, General Counsel for DCF. So once Kern-Hatton is no longer licensed as a residential treatment program, DCF has no more authority over the regulatory aspects of Kern-Hatton. We can continue to do abuse and neglect investigations in that function, but we do not have any more regulatory function. And that was one of the benefits of, frankly, of Kern-Hatton being an RTP, is that we were able to do this regular eyes-on of the facility, but that no longer exists. Jen, if you want to address any of the issues around, oh, excuse me, Senator Lyons.
No, go ahead, finish up.
I was just going to pass it back to Jennifer Benedict to address the issues of abuse and neglect investigations if she were interested in doing that.
Yes, thank you.
Yes, absolutely. Thank you. So as stated in my closing remarks, if there are additional reports of child abuse and neglect accepted within any agency of education facility, private and public, it would be my unit to conduct those. However, those are confidential and I'm not able to speak about that if they were to be accepted.
And do those, so do the complaints go directly to the 800 line, or do the complaints go to the district office?
They go directly to the 800 line, and then the 800 line, the centralized intake unit that receives those calls, disseminates them to the appropriate entity, which would be my unit directly.
All right, so at this point, those are totally confidential, and in order for us to know whether or not complaints are of abuse and neglect have been made, we would have to go a different route.
That is correct.
Thank you. Okay.
Senator Lyons, maybe just for
Yes, go ahead, Senator
clarification.
Campion.
Thank you, Senator Lyons. So is someone from DCF or the Agency of Education visiting the site, checking in on children, checking in on the situation?
Only in the event of an individual abuse neglect allegation. There is no more regulatory function over Kern-Hatton by DCF.
If I may.
As a result of the closure of the RTP, we have no more regulatory authority over that facility.
And also, given that there are no youth in the care and custody of the Department for Children and Families placed there, we wouldn't have the need to visit any of the children there. That sometimes when we have kids in our care and custody, you know, our social workers will do site visits and check on the status of kids in foster homes and other settings. We're required to, but given that we do not have any state-placed youth there in DCF custody, that we don't have the ability to you know, just to jump in. We don't have the regulatory authority, as our general counsel has indicated, just to drop in and do site visits, unless we have a specific allegation that we're investigating.
Thank you.
So I guess the question would be that once the decision of closure that you have talked about, or revocation, which that the children who were in state custody have been moved from Kern-Hatton. Can you tell us how those children were moved and where they are?
There were at the time this past summer, and I'm speaking from memory, Senator, and we can get you more detailed information in this area. There were a few state-placed youth in their program. We did move them, and I could give you more details on that within the confines of confidentiality of what we are able to share. But you know, it was a program that had been utilized historically for state-placed students. We are no longer utilizing that program, and there were a couple youth that we moved to other programs, is my understanding, this summer when we went through this process.
We'll be interested in hearing that, I think, at least in our committee, to know the disposition of the kids, how they're doing.
You know, and I think, you know, this conversation has highlighted one of the, you know, the tension in our role here as a child protection agency, but also as a regulatory agency as well. You know, we had been working with Kern-Hatton as a residential treatment provider, but also, as you heard from Jennifer Benedict, in terms of investigating specific allegations of abuse or neglect under Chapter 49 of Title 33. As a regulator, you know, we look at programs and we do work for programs to come into compliance. We were working over a span of time to have Kern-Hatton come into compliance with certain areas, but also concerns that they really were not operating as a residential treatment program. And so it was a very complex case that we're involved in here with Kern-Hatton in terms of the different functions they serve as and our different roles. and also understanding, that as we are involved, we do have the ability to continue to monitor and oversight what's happening in their program, but also trying to honor our role as a regulator, making sure that programs that operate as a residential treatment program who are licensed are actually residential treatment programs. And we had determined they didn't fit that definition. They were more of a boarding private educational institution. And we worked with them to meet certain conditions to wind down their license. However, given our role, we were prepared, to go through the revocation process if we were not able to reach that satisfactory conclusion of them relinquishing their license, given the complexities of the situation.
So you've led me to a question that I wrote down earlier, and I'll ask it, and then I know Senator Sears has a question, and that is, and this I direct, I think I direct it to AOE, DCF, and afterwards, I'd like to hear Steve Harrison's comments as well. It sounds like there was some that closure might have been a negotiated agreement to allow the school to continue, and I'm concerned about that. Just so I'm trying to understand that decision around closure. I don't know that I'll let Senator Sears ask his question first, and maybe we'll come back to this one. Senator Sears.
My questions, but I wanted to make one comment earlier on. Those who may be watching on YouTube and being frustrated by some of the conversation here, this is a beginning, a very iffy beginning, to try to gather information by 3 separate committees. And we will continue to look at this issue throughout this session and into the future, I'm sure. This is the beginning and not the end. So I want to make that clear. One of my concerns, and this is for both AOE and DCF, is the failure of apparent failure of Kern-Hatton employees to report as mandatory reporters child abuse and other allegations that have been made. And how does each department, do you work together on this, or is this separate silos if a teacher at Kern-Hatton fails to report child abuse? If a house parent fails to report child abuse? How do the 2 departments work together when you're both licensing a program? I'm thinking just up the road or down the road is Kimball Union Academy, which is a separate, completely independent school. So how does that, these are allegations of child abuse.
If I may begin, would that be okay with the parties attending? Okay, sure. Thank you. I appreciate the question. It's a great dilemma. Do we work together? Yes, to the ability we are able to and share information, in that my unit regularly communicates with by way of formal documentation and less formal conversations, frankly, with our partners at the Agency of Education in the independent schools sector. And when there are joint investigations, child safety interventions, so sort of the highest level intervention, through our memorandum of understanding, the Agency of Education does receive a great level of detail when those investigations involve allegations against licensed educators or incidences alleging staff have committed abuse. However, well, actually, before I move on to that, I also want to state that when certain child safety interventions are accepted that allege sexual abuse, when the alleged perpetrator is 10 years old or older, we work in tandem. We are required at DCF to report to law enforcement. So if in the context of those joint investigations with law enforcement, sometimes Agency of Education is also notified, depending on the nature of the allegation. If in the context of those child safety interventions, we identify a failure to report, law enforcement is aware, and as each potential criminal investigation unfolds, the law enforcement officer talks with their local state's attorney to determine what charges are appropriate and what are not. That falls squarely within the jurisdiction of the law enforcement, but those conversations do happen in each of those cases where things are identified that reveal a failure to report.
So
Sorry.
DOE, how do you handle?
So on our end, we could receive the information about a potential failure to report either directly or from DCF. So if we receive the information directly from an investigation we have ongoing, we inform DCF of what we found so that they can follow their process. But our ability to intervene when there is failure to report is to take action against any licensed educators. If the individual is a licensed educator, we have the ability to hold a hearing and revoke a person's educator license. And again, in the case of an approved independent school, failure to report could be a violation of the approval status, the privilege of being approved, and that could lead to revocation of approval status. Not every failure to report will automatically lead to failure of approval status, but if it appears that the head of school was not aware, it's a really important step that we take to communicate where we have found a failure and that the head of school understands the seriousness and also takes any appropriate employment actions within the school.
Thank you.
Okay, good. I mean, that does get back to my, it's not a rhetorical question, but it is an open question that I think it would be helpful for us to explore. And that is, was the closure a negotiated agreement to allow the school to continue without formal continued investigation on the part of DCF?
Yeah,
Who wants to
Senator,
try
if
to
I
answer
could,
that one?
yeah, if I could jump in here. So our regulatory role is whether to license a facility or allow them to voluntarily relinquish, like happened here through our work and a negotiated relinquishment, or we could have moved for revocation. Here, we worked with them and set some parameters for them to relinquish their license. And we allowed them to do that. But we don't have authority to shut them down, to have them cease operations as a program. That's not within our statutory authority to do that. We license or unlicensed programs that provide treatment to youth. Once they were no longer a licensed treatment provider, they still had the ability to operate as an institution, as an educational institution.
So I guess then that goes to what treatment services were available at the school when they were licensed initially in 2017. So we're talking about that time frame, 2017 to 2019 in that area. So it was their commitment on the part of the school to provide treatment services. And then are these the treatment services that they failed to provide and then resulted in closure rather than revocation?
And if I could jump in here, and I may have Jennifer jump in here and provide most of the response to your question, Senator. But just for context sake, and Jennifer, please correct me if I'm inaccurate, but the license that was relinquished recently by Kern Hatton was initially obtained, I believe, around 1997 and was renewed continually there, is my understanding. Jennifer, please correct me if I'm wrong, but I think that's when this license dates back to.
Regardless of when it dates back to, there was approval in 2017 based on certain services being provided to kids. So I'm trying to understand if the licensure included these treatment services and they were not provided, then how did it get to closure? I still don't understand that. And I don't know what role, if any, AOE has to play in this response, but would be helpful to hear also from them. Go ahead, Jennifer. Benedict, you.
Okay, I'll do my best, Senator Lyons. I am not trying to dodge your question. I'm just trying to
I
be
get it.
articulate. So in 2017, you're absolutely correct. There were concerns identified. Looking back in the previous term they were licensed 2015 to 2017, there appeared to be some changes in the admissions of Kern Haddon, taking higher acuity children, and we in my unit continued to conduct interventions and make recommendations. And as stated, the outcomes when things start to emerge, things being patterns, the outcomes of regulatory investigations they start with educating, informing, trying to understand what the program is doing, what their vision is, and they progress to more serious violations and then ultimately either closure or revocation if things aren't remedied. So in 2017, we started to have those conversations with Kern Haddon, identifying that their counseling department was insufficient. There were 4 counselors to an approximate capacity and census of just under 100. We identified that as I stated, that the kids that were coming to Kern Haddon were a different profile than they had historically been. And we were worried about we were starting to see themes emerge, and we were asking a lot of questions. We were also worried about the supervision level, given the higher level of acuity. However, there weren't enough, I would say, interventions and violations cited at that point to be talking about revocation or license closure. And to be frank, based on these concerns and the program's intent to seek accreditation from another body, which does have standards that oversee health and safety standards for children, there was discussion about postponing the closure of Kern Haddon until there was another accrediting body with some oversight. So throughout this time period, the serious discussion started in 2017. We paid increasingly more and more attention to these different themes. And by the time 2019 came around and we assessed, it was very clear, both on our assessment and Kern Hatton's stated intent to not come into compliance with residential treatment program regulations because they did not identify as a residential treatment program. So we were, in a sense, stuck with feeling very concerned about what was happening with some level of oversight and recognizing that we were regulating a program that wasn't, in fact, what they were regulated as. Does that make sense?
Sort of. I'm trying to make sense of it. As Senator Sears has said, this is just the beginning. So we will have a further testimony in this area in health and welfare and possibly other committees. So thank you. Emily Simmons, did you want to add anything at this point?
I don't have anything to add except to reiterate that I am so happy to hear that there will be ongoing discussions. I have noticed a few things that I don't think I would have noticed about our statute and DCF statutes if these facts had not come to light. And I think there is a need for more oversight of a boarding program within the State Board of Education's rules. And just to reassure you that we're putting action steps into place, the State Board of Education has an early draft of a rule that will begin the formal rulemaking process this summer that does add additional requirements for standards that a boarding program must meet in order to obtain approval for the school itself. So a school that wants to be an approved independent school and receive those public dollars that also enrolls boarding students would need to meet the standards of NEASC. A lot of you are familiar with NEASC accreditation of that boarding element, which is a direct lesson that we're already taking from the just general themes, not the facts themselves, but the general themes and questions that we've had as this process has unfolded.
Thank you. Other comments? Secretary French?
No, I just, my takeaway from the line of questioning is parallel to Emily's observation. It's, the question is the current regulatory construct sufficient both individually and then collectively among the agencies? And I think that's a good question, and one I certainly feel more comfortable answering after our investigation is reviewed. I think, as Emily pointed to, there are themes I think we could talk to, and I think she's spoken to them. But the specific lessons are one I just reserve comment on at this point, but welcome the opportunity to debrief on it once our investigation is concluded.
All right, thank you. Yes, and so we've heard that the investigation is to conclude. We heard in a few weeks or soon. Is there a definition for that? What's the timeline?
I won't give a timeline. I'm sorry.
Yeah.
I'm uncomfortable boxing in our committee and putting any pressure on them to wrap up before they feel they've done their full job.
And I
Well,
unfortunately tried to do that once before, and
Okay.
without understanding the parameters of COVID and so forth, so I'm reluctant to do so as well. But it's progressing. Should be
Okay,
wrapping up
thank
soon.
you. I want to move just one last set of questions. I think while DCF and AOE were here together, and you've both brought up the issue around COVID and the difficulty of investigating during COVID. Has there been any on-site investigation? Obviously, some of the complaints that we've heard about relate to issues on site, so with kids. So can you maybe briefly talk about the extent of on-site visitation investigation?
I
Well,
can
go
say,
go
Senator.
ahead. Well, I think I'd rather start with the AOE because I know they're on a bit of a time crunch, and then we'll go back to you, Commissioner Brown. Sorry to interrupt.
Thank you, Senator Lyons. There's not been any AOE site visit to Kern-Hatton. Again, we did not foreclose or make a rule that the committee could not visit. They have used their best judgment and have not requested for us to make possible. I'm sure we could have figured out COVID precautions in order to make a site visit if it were necessary. The nature of the regulations and the statutes that we're investigating have not required a site visit at this point. We're talking about compliance with statutes on the books and looking at procedures and protocols, that kind of thing. And so, the secretary indicated it's been difficult because of COVID. I can tell you, as the person who, supervises the individuals who are on the committee, if they had come to me and said, we feel like we've got to go down there, we would have made it happen. And that request has not been made.
Thank you. Commissioner Brown.
Thank you. I would point out that the site visits contained in the report that we've shared with the committee all occurred pre-COVID and allowed us to finalize and move forward with our work in the resolution in this case that we're talking about today. But I would say in terms of specific child safety interventions, that work continues throughout the pandemic, and we do respond with law enforcement on site or in person in response to cases that we deem need an intervention and an investigation. And so we are out in the field and in people's homes and facilities conducting investigations when required.
All right, thank you. Senator Sears or Senator Campion, any additional questions? Because what I'm going to suggest is that the committee take a 5-minute stretch break and then come back at 10:40, just before 10:45, so we can move on to our next two witnesses. So are there any further questions?
I don't have any at this time.
All right, thank you. All right, so Nellie, we're going to take a break. You can put the screen up and everyone be back before 10:45 so we can start on the dot.